go over the Cincinnati exclusive right to list agreement. Some of this document is going to look very familiar, so I'm going to kind of blow through it. I mean, the main reason that we're having this conversation is in regards to, looks like it's going to be section 14, so let's jump into it. So section 1 is really talking about the high level of the contract. You know, you're going to put something, let me say this. I'm going to talk about the contract, and then I'm also filling out a contract, and you'll be getting a copy of the filled out contract as well. So you may put something about the start time of when this listing starts, called the commencement date. So it could be noon of 8/15 of 24 and expire on, let's say, 12/31 of 24. The address being listed is here. Then you're going over here to the city or township, the zip, the county. Down here in line 7 is where you would put parcels. If you don't have enough space, then that's where you might want to put something about see attached addendum, listing addendum, something to that effect. The sum amount would be the amount that you're listing it for. And again, a lot of this is in place today, so I won't insult your intelligence by going through it. There's a lot of information here as to what's included or excluded from the sale. I always tell agents, you know, at least once a year, read this, because I think you're going to find something in here that you would probably say, you know what, I didn't know that. You know, so the one I always point out, only because it's changed over the years, is the television and/or the sound system mounting brackets. Again, that would be excluding the television. So the mounting brackets would stay, but the TV would go. So, you know, those kind of things show up in these documents from time to time. And because we don't necessarily use them, we kind of lose that mentality of, you know, I forgot that was in there. So, so this talks about number of parking spaces, number of storage units. That might apply to a sale somewhere down the road. Then you're checking things here in line 33 that have to do when they apply to a satellite or a satellite dish, which my editorial comment is, when does that go away? I'm not sure any of those much exist anymore, but I realize they exist. It just is very few and far between. 37. Something that might be the following items are excluded. So maybe it's the garage refrigerator. Something like that would show up. No initials to the... I've noticed that none of these pages have initials at the bottom, although I'm kind of used to that in the past. So I'm not sure when that went away or if it went away in this version. But in number 4, anything that shall be included in the marketing of the real estate. If nothing's added, NA is what you would put. Again, we're going to keep trucking because we aren't necessarily talking about these things. Seller notification. Seller certifies to the best of their knowledge the following about real estate. And so this is a point where the seller would contradict or correct, I should say, maybe what a buyer's agent may put in here. And so that's that item. Lead-based paint, anything prior to 1978 requires lead-based paint and booklet. Those are all in our master library, residential property disclosure. There's only 7 exemptions. If one of those 7 exists, you can use the exemption. If that's not the case, then you would use the Ohio RPD. If there was an association for a condo or a homeowners, you would dive into section 10 and fill those blanks in that apply. Section 11. See if I made any notes. No, for me, section 11 doesn't. It's probably not going to apply, and if it doesn't apply, then you would put NA where those blanks show up, and we're to the dreaded section 14. So I think the thing to keep in mind about section 14 is is I'm going to read you line 152. The terms of the compensation, legal notice regarding compensation, brokerage fees, and commissions are hereby set by law, are fully negotiable, and may be paid by the seller, the buyer, the landlord, the tenant, or a third party, or by sharing or splitting the fees between the brokers. I feel like they put everybody in there except the candle maker. So that's my joke at this point. But I'll try to refrain from making the rest of those. Section 14, as it pertains to the following, what you see on the screen, because this is a public-facing document, I will not and cannot talk about what should go in the blanks. I would kind of point you back to what I've attached to your email as it pertains to an example of what I would put. So sorry to kind of ditch on the video in this section, but in writing it's pretty self-explanatory. So what you're doing here is the seller agrees to pay a dollar amount or a percent, which is the total of the total compensation. What you're putting in 162 is a dollar amount or a percent, and in the buyer side a dollar amount or a percent, of which those two dollar amounts or those 2% would add up in sum would equal what's in 158, right? So unless, of course, the seller elects not to pay any compensation to the buyer broker, whereby they would select line 172. So that's a high level. My example gets a little more specific. Protection period. This is the period of time after the listing, if it was procured and you had a buyer that popped into the property during the time it was listed and then bought it after the fact. I usually recommend something in the neighborhood of 90 to 120 days is what I normally put. The rest of this has to do with authority of MLS. I'm assuming most of you guys are putting in yes. 18 authorizes or does not authorize the use of a sign. Section 20 authorizes the use of a lockbox and who can use and access those lockboxes. And electronic surveillance. This is an important one that I don't think gets brought up enough, and so I'm going to take a second just to kind of go through it. And that is, they do or do not have surveillance equipment. That's all fine and good, but down here in line 233, the seller agrees that if such surveillance device is present on the property, that the seller will turn off any audio feature of the equipment while other persons are present in this property. That's huge. So I think by and large, the conversation needs to follow the letter of the paragraph. But if they're going to list their property, they need to respect others and not use those devices. So the diligence needs to be used. And if they feel that something is, if they feel we're correct or incorrect, then they need to seek legal advice before they sign this contract. Section 23 talks about a home warranty. They do or do not offer it. Title insurance. The seller currently does or does not hold title insurance. I find a lot of times sellers aren't real sure if they did or didn't have it. So that might be some investigating that has to happen. Section 25, 26, 27. Again, there's really nothing we need to go through. If you have nothing for 29, that would be a great place to put NA. And I believe that gets us to the end of the document. So in this, you're going to, obviously you have space for two sellers. In the bottom section, you would put the listing brokerage firm would be Remax Alliance. The broker is Mike Seagraves. The manager, again, is Mike Seagraves. The listing agent is Tony the Tiger. I don't know. Put somebody, whoever you are, in there. Your phone number, your email, and the date and time of when you signed it. However, if you signed this through .loop or some electronic means, it's already date and time stamped. There's no need to utilize that. So I hope this helps, and be looking for the attachment. Take care.